All right, welcome back to Conversate with Akeem D. Earl, and I am back with another very special guest, Mr. Gary Kohlman. Mr. Gary Kohlman, thank you for being on the podcast.
And it's a pleasure to be here.
Awesome. So the intro question to this podcast is, if I was not an attorney, I would be a what? It's a finish this sentence.
The fortunate thing for me is that all of my skill set probably only works as an attorney, and therefore it's not an easy question. But I do love and have a passion about sports, so I could imagine myself being a sports writer. I've also got somewhat of a background in music, and although I don't see myself necessarily as a performing musician, I could see myself in a background in terms of managing a band, which I've done in the past, or something like that. But sports writer is probably the one area that I could see I might have been able to be successful in.
Sports writer. What sport would you write for?
Well, as you know, Akeem, I was the general manager or general counsel for the National Basketball Players Association. So I do like basketball, and I played basketball for a while in college. But baseball is my number one passion. So I think I'd enjoy very much writing about baseball.
So we could jump into it. Like you said, you were the general counsel for the National Basketball Association, which is huge. First, how do you even get that job? And then what is the general counsel for the National Basketball Association, the NBA?
So yeah, this scrolls back to advice that I would give to younger lawyers. Throughout my career, I've made connections, not necessarily with any direction, but just simply tried a lot of different things, met a lot of different lawyers, and had a lot of different experiences. And one of my experiences was when I was at the Public Defender Service, recruiting and mentoring a lawyer by the name of Michelle Roberts. She later became a partner of mine in a small firm I had. Michelle became the first ever African-American female to be the head of a players association. And because of the connection that we had, she asked me to be the general counsel. So that's how it came out of absolutely nowhere. I didn't realize until midstream that Michelle was even applying for the position. And after she got it, she was interviewing people across the country for the position. So I didn't expect to be asked by her, but I was. General counsel handles all the legal affairs for the players, and it's both on the court conduct, disciplinary actions, as well as off court, which a lot of the things that I did off court you wouldn't know about, because the whole point was to keep them as quiet as possible.
So people don't know. Exactly.
Right. But the other thing that I did and was really challenging is I negotiated a $90 billion collective bargaining agreement. I was basically the chief spokesperson for the union in negotiations with the NBA. The collective bargaining agreement sets forth all the financial terms for all the players. It sets forth the guidelines for all the player conduct on the court. It's the comprehensive. It's 450 pages, and so that was quite a task. It was over about 3 years, and I worked very closely with C. Paul and LeBron and Carmelo and a lot of other players who were on the executive committee to negotiate that contract. So that was the primary responsibility I had.
Man, how was making that transition though? Because I can't imagine you say you're at PDS, you're handling various criminal trials, and then you transition into going to work and you have LeBron and Carmelo walk into your office. Like, how do you even manage that in your mind? Because I know I'll be going crazy. That would be crazy for me.
Well, it was quite a transition, and I had a lot of interesting first encounters with the players. But I mean, at the end of the day, the other piece of advice I would give to younger lawyers is that when I think about what a lawyer is anyway, he or she is a problem solver. Just like I have no idea how to fix my car, and I take it to a mechanic, and I hope that he or she can do it. By and large, from Public Defender Service on, I've seen myself as a problem solver. So the players, although they're taller and more athletic and sometimes more demanding, I suppose, than some of the clients I've had, still you're trying to solve problems. So if they have problems on the court, you're trying to solve them off the court. And the bigger problem they have is getting a fair collective bargaining agreement from the NBA. And that's the problem that I solved. And so you work with the clients just like you would work with a client that had a fender bender. I mean, at the end of the day, you're trying to help him or her out of that particular matter. But it was quite a transition. There's no two ways about that.
So why? I don't want to call it difficult, but what is the difficulty with going into that bargaining agreement with the NBA? Because we even see it now recently with NBA players. I think recently with I forgot the player from the Pelicans. He's like the spokesperson from the NBA who's on the NBPA, and the issues and the back and forth that goes into how much the players deserve or how much they make. And even the difference between like how much a player, like a bench player makes now compared to what a star player made in the 90s is like a stark difference. What is the difficulty in being in those negotiations with the NBA in terms of like how much money a player should get? These players should
get? So you touched upon two different issues here, and let me address both of them. First of all, there's a pie, and the pie is made up of all the revenue that comes in for basketball. And the arm wrestling primarily during negotiation is who's going to get what percentage of that pie. So when we came into the negotiations, this is 2015, 16, 17. In the last 4 negotiations, 3 times, the owners had locked the players out. In other words, the negotiations had stalled. And when you get locked out, players are locked out. That means they have no paychecks. They can't go into the gym. There's literally no basketball. So we had to tread water. You're treading water, basically. You're on the one hand trying to get as much of that pie as you possibly can for the players, but you don't want to push it so much that the owners say, okay, if that's your position, that's the end of the negotiations. You're locked out. There's no season. And that has happened. And as I say, 3 times in the last 4 times. So we were trying to get back some of the percentages that had been lost in an earlier negotiation because of a recession. So that's the challenge over here. The other thing that you've identified is how do you make the collective bargaining agreement fair to both the star players, the Michael Jordans and the LeBrons and the Carmelos, but also take care of the people that are 11th, 12th, 13th, the non-rotation players, who probably statistically are only going to be in the league 2 or 3 or 4 years. I mean, that's the cold reality of the situation. So we had, it was important to have many of the star players next to me during the negotiations, but we tried to also give a voice to the journeymen, the players that were never going to be making max contracts or even close to that, to try to make sure that it was a balanced negotiation. But that is a challenge to make sure that you're covering everybody.
Yeah. How is it working with those caliber of players though? Like just generally just working with Carmelo, working with LeBron, being in those rooms. How was it working with them?
Many of them are exceptionally astute in terms of the finances and the realities of the collective bargaining. James Jones was on the executive board. He's now the general manager for Phoenix. If I had a Fortune 500 company, I would make him the CEO of that.
Wow.
Heartbeat.
Really?
Chris Paul is an inspirational leader. Fantastic.
Wow.
LeBron, many smart, intelligent questions, a student of exactly what we're doing. I was surrounded. Kyle Korver, another one. Very, very astute, very sharp, very helpful during negotiations. Across the board, the executive board was very strong. But let me tell you one little tidbit, though, that as strong as those players were, to a person, I think the players are going to be a little offended when I say this. The one person that still intimidates the hell out of them, Michael Jordan.
Really?
Michael Jordan was on the other side of the table now. Keep in mind, he used to be a strong union person when he was a player.
Really?
Now he's an owner. And so he was on the other side of the bargaining table, and the owners would defer and use Michael at times as a spokesperson. And when Michael spoke, my players listened.
Sometimes they shut down.
Very strong. He's to this day, a very powerful, very intimidating force in a room, for sure.
That's crazy because you hear the stories. You always hear the stories about how Michael Jordan was on the court and how he was with his team. Is very demanding leader on his team. Like the level of excellence that was needed from Jordan was out of this world. You hear the stories. but to be in that room and see it and actually feel it, that's crazy.
Oh my goodness. I mean, we would get in situations I would be asking for whatever I was asking for. And Michael would say, Kohlman, you don't know what the hell you're talking about. You've never played in the NBA. And I would look to support from my executive board of the people that I'm talking about, to back me up. And they would be looking at me like, maybe it's time to have a recess and discuss this a little bit.
What do you want us to do? That's Michael Jordan.
Yeah.
Wow.
To this day, by every single player in the
Man, that is powerful. That is powerful. So I do want your opinion on the NCAA, college basketball, and these NIL deals. And obviously, I'm sure that was bargained for on behalf of the players. How does something like that happen? And how do you feel about college players being able to get paid?
So, Keem, I think you and I might have talked about this, but I actually started or helped start the whole movement in this area in 2014, before I became General Counsel for the basketball players. The Steelworkers hired me to represent basically the football team, the Northwestern football team. And the Northwestern football team organized like a union, just like it's happening across the country in factories and at Starbucks and other places like that. And the players voted to be a union. And we actually had a trial in Chicago and Evanston, in which a labor judge ruled that they, in fact, were entitled to be a union. That ruling, for technical reasons we don't have to get into, was overturned. But it was the beginning of the movement to give players in college sports a voice in terms of what their conditions were. So, I followed it like any other sports fan ever since, and that's the last involvement I've had in that particular issue. And on the one hand, I think most people agree that players need to be compensated for what they do and what they bring to the table. On the other hand, it's obviously become a very difficult issue in terms of exactly how to, again, a pie. We're talking about money, and we're talking about how it's going to be allocated. And it really comes down to the same issue that the NBA and the NBA Players Association have to deal with every several years, and that is, how do you equitably divide an extremely large pie that's fair to both universities, but also, more importantly, to the players.
Man, that's real. It's so interesting to me because I feel like these corporations, the NCAA, the NBA, they're making billions of dollars. And if you're able to pay multiple players over $100 million, if like that's what you settled on, and they still feel like they're still making a profit, it's like, why is it so difficult for them to be like, okay, here, you take an extra 100, it's like you're already making billions. You already have, your bottom line is set. Is it like a accumulation thing? What do you think it is that makes them want to hold on to as much money as possible when they already have enough to take care of themselves and the next 3 generations?
Right. Well, Keem, I think we're now getting into, larger macro issues like capitalism and whatever else. I mean, it comes down to, here's an issue that I tried to put on the table, and someday I think will be on the table. And that's franchise values. So you're alluding to the fact that you buy a team, let's say, for $1 billion, and then within a year or two, it's now worth $2 billion or $3 billion. And these are, actual real numbers. Shouldn't the players get a percentage of that? Forget income now. The income is TV revenue, the gate, things like that. But now I'm talking about a separate issue, and that is, shouldn't the players share in the upside when these teams, when they're sold, go for, huge amounts of money? And I made a little effort to try to put that on the table back into the negotiations I was doing. The owners were not very receptive. It'll surprise you to the idea that they would be having to share, the profits that they had made and the value that had accrued. And my point was, yes, you own the stadium, and yes, you've got this, and yes, you've got that. But people are not coming out to see a bunch of old, white, fat, guys running up and down the court. They're coming to see the players, the ones that are giving the value to your stadium. But I think one of these days that'll be realized. It hasn't been realized.
And I feel like that'll also be another difficult thing, because obviously that makes sense for a LeBron or Anthony Davis or Anthony Edwards or John Morant. but it may not make sense for like you said, a bench player like to have franchise, to have ownership or to have shares in a company? Or are you saying every player should have at least a small pie
Yeah, no,
piece?
every player, yeah, and how it would work, the mechanics of it are tough because, as you know, not too many teams are sold, so the value is
Right.
actually accrued when they're sold. So you'd have to figure out a mechanism during the course of each year to figure out the upside of the value going up, and then, but it would be very similar, frankly, to how the pie is distributed. I mean, in the collective bargaining agreement. I mean, the
Yeah.
fact of the matter is, as you're alluding to, there's a handful of players that are bringing the fans to the court, and
Yeah.
and yet without the rest of the players, you wouldn't have a basketball league. So you do
Sure.
need the journeyman and the
Sure.
seventh and eighth and ninth players, the
Yeah.
rotation, etc. So these are challenging issues, but I'll say this much, and it's true in baseball as well, and
Mm.
football. The star players do generally recognize the importance of spreading the wealth, so to speak. That's been my
Mm.
experience, not only in the NBA, but in contact that I've had and the representation I've done in other sports leagues.
Man, that's real. So you have this amazing job as general counsel of the NBA. What made you leave? Like, how do you leave the NBA?
Well, it was a fantastic job. I had finished the negotiations, and these collective bargaining agreements are usually 5 or 6 years. So after
Mm.
that heavy load for 3 years of negotiating it, I did have an apartment up in New York in Harlem, and I loved
Mm.
that. But I was going back and forth between New York and my home in D.C., where my friends and family are. And at
Yeah.
some stage, I decided it was time to come back home, so to speak. But it was a great job and a difficult one to leave.
Yeah. So you said you also worked at PDS. How would you define yourself? Would you define yourself as a defense counsel, as a private counsel, or just a general practice lawyer? Like, how would you define Gary? If somebody asks you, like, what do you practice? Because I feel like you just touched so many different areas. How would you define yourself?
I think at the end of the day, a trial attorney.
Mm.
Tried cases in over 20 states. I mean, I was at the Public Defender Service for many years, but then in my own practice and later with a labor law firm, I've been trying mostly criminal, but a lot of civil cases as well. So at the end of the day, a trial lawyer. And I guess, as I alluded to earlier, a problem solver. Trial lawyer
Oh,
and a problem
absolutely.
solver. Well, although a trial lawyer is essentially a tool to solve problems. So,
Mm-hmm.
I mean, it's really kind of part of the problem solving process.
Yeah. So I do want to get into a little bit about even how we met. You were a special advisor at my job, the Office of the Attorney General. That's how we got into it. And I saw firsthand you passing on the knowledge and your expertise of being a trial attorney to attorneys who were in practice, who were doing it. At what point did you say, okay, now I'm ready to pass on the knowledge? I'm able to train attorneys. Or what point did you feel like, okay, I have enough information, enough knowledge to pass on?
So the Public Defender Service that you alluded to, the one in Washington, D.C., is reputed to be
Mm-hmm.
probably the best one in the country.
Yes.
And one of the reasons that it has that reputation is that it's well funded. The caseload is not as onerous as it is in many public defenders across the country. So when I was at the Public Defender Service, after 4 or 5 years of not only trying lots of cases, but actually arguing a case in front of the Supreme Court, I became the training director at the Public Defender Service. So my job for the next 2 years was to train the new lawyers that were coming in. Thereafter, all the way through my career, I've stayed active in training and teaching. At Georgetown, I taught a class for several years. I used to go up to the Harvard Trial Advocacy Workshop when Charles Ogletree, a very close friend of mine, was there for many years. When I was at Breithoff and Kaiser, a labor law firm, I trained the lawyers there. So the training part and the educational part is something I've always enjoyed. And it started way back early in my career.
Man. So speaking of being at PDS, I mean, being a prosecutor now and obviously seeing the hustle of what a defense counsel has to go through, how was your time at PDS? How was that being in the thick of it, in the hustle, in the time that you were at PDS? Like, how was that experience?
So the Public Defender Service is like Neverland for Peter Pan. It's a place that most people say they wish they never had to leave. When I first came to the Public Defender Service, this is something that could not be captured in a book or a movie or a TV show. When I first came to PDS, it was just getting off the ground. It had just been funded by Congress, and it was in the very early stages. You walked into a bar, and if you went to your right, you could order a drink, and if you walked up the steps, you could get a lawyer. That's where the Public Defender Service was, right by the court. And when I walked up those stairs, I saw this group of lawyers, black, white, men, women, just having the time of their life. And I said to myself, I was still in law school. One of these days, I better work here. And that's what happened. When I came, they were just remarkably talented Supreme Court law clerks, just very, very bright people, passionate about doing criminal defense work. And I basically learned how to be a lawyer from watching and mimicking them. And a lot of the things that I became well known for in terms of my courtroom theatrics, I borrowed and mimicked from lawyers that were there. And then as you stay there after a few years, you start to be that kind of a mentor to the younger lawyers that come in. And that's what I mean by it's a hard place to leave. It's just a wonderful environment to learn how to become a trial lawyer. And the lawyers that have left the Public Defender Service, I mean, as you know, even your boss for a while was a public defender, Carl Orsini.
Yeah.
There are Pulitzer Prize winning public defenders. There are leading professors. Charles Ogletree, that I referred to, was a mentor for Barack and Michelle when they were at Harvard. MacArthur Genius Awards winners across the board. The Public Defender Service has branched out now. It's almost like a mafia, basically. Their tentacles are everywhere. I'm doing death penalty work now in Texas, and there are many, many former public defenders who are down in Texas or have gone down to Texas to do death penalty work as well. So anyway, it was a wonderful place to work at and a wonderful place to learn how to be a
man. That's amazing. And I know I have some mentors that are from PDS. There were so many amazing attorneys that came out of PDS. And so you spoke about being able to identify great attorneys when you walked in. You saw amazing attorneys. What would you say makes a great trial attorney? What are the attributes of a great trial attorney?
Well, that's an interesting question. I mean, it starts with, I think, storytelling. I think a good lawyer is able to, and this is not controlled by personality, because I've seen some very soft-spoken people, and I've seen some very, boisterous, theatrical lawyers as well, that are both in the whole range of personalities can be effective.
Yeah.
Because it starts with the ability to look at a case, size a case up, think about it, and then be able to tell a story to a fact finder, whether it's a judge or a jury. And if you can't do that, then you're not going to get anywhere, because litigation itself, and particularly in jury trials, which is mostly what I've done, but this works as well in arbitrations and when you're in front of a judge, is basically two competing narratives. So I'm a defense attorney and you're a prosecutor. Prosecutors, of course, have got to have a narrative as to what happened and what their theory is and why they've charged somebody. And the defense attorney has got to be able to get up right away and tell a different narrative and try to sell that to a jury. So if you can't do that, if you can't think through a case and you can't come up with a way of verbalizing it and turning it into a story, you're not going to get anywhere. I mean, the rest of it comes from practice. There's just in terms of learning the basics of the rules of evidence and becoming more and more comfortable in court and understanding the law. But it's the storytelling that's the key, I would say, to being an effective and a good trial.
Yeah. Now, I do want to ask, you've done a bunch of different things throughout your career across the different spectrum of the law. What is your decision-making process to taking the next opportunity? Because I know for a lot of young attorneys coming out of law school, you feel like you need to have like the next 5 steps and the next 5 decisions and opportunities lined up as you get out of law school. Throughout your career, what was your decision-making process going from PDS to MBA to doing the next thing? Like how have you made the decisions? Is it consulting with the wife and children? Is it consulting with the friends? Like how was that process of taking the next step, taking the next journey in your law career?
Yeah, I mentioned this a little bit earlier. I think that the decision-making process is easier, or you'll have more opportunities. Let me phrase it this way: if you expand the context that you have, and I guess what I mean by that is, okay, public defender service. We were doing criminal cases. When I went out into private practice, I started dabbling with all sorts of things: civil cases, domestic relations cases, SEC cases, and eventually union cases. And by doing that and getting into other areas of law, opportunities opened up. So after a while, friends of mine had gone into the labor movement and were at a labor law firm, and they knew that I had trial experience and done a couple labor cases. And so I suddenly found myself at the premier labor law firm in the country, Brett Huff and Kaiser. I talked to you a little bit earlier about how the General Counsel, because I mentored Michelle Roberts, I stayed close friends with her, and she was in my law firm, so that when she had that opportunity, she in turn gave me an opportunity. The Attorney General's position was very similar to that. I'd known Carl, and Carl was looking for somebody to do some training at his office, and suddenly that opportunity materialized. So I think my advice is try as many things as possible, have as many contacts as possible, and keep your ears open, for when a new opportunity comes along that might challenge you.
Yeah, that's real. So I do want to get into some things that I've read to a couple of people that you've represented before in criminal trials. I do want to hear some stories or that experience of how you've done that. Specifically, Edward Tickle. I read that you represented Edward Tickle, who was tried for robbing the FBI credit union. How do you even get that call to do that? What was that trial like? What was that case like? What was that preparation like? Tell me all about it.
Yeah, it was an extraordinary case. Ed Tickle was, to walk into some background, Ed Tickle was what they call the black bag man for the FBI. And what that means is that he was the person that would basically, sometimes legally, sometimes illegally, go into mafia homes and offices and put in wiretaps and bugs. And he was skilled at defeating the locking system, security systems of particularly mafia people, but others as well, in organized crime. And he was a legend at the FBI, so much so that walking into the FBI with him was like walking into Yankee Stadium with Mickey Mantle. I mean, he was like, everybody revered him. Wow. But he was alleged, as you've alluded to having broken into the credit union of the FBI and caught inside a locked vault, and was charged with that, as well as masterminding a diamond heist in Virginia, as well as stealing FBI radios and giving them to a famous race car driver by the name of Richard Petty. So we were facing with trials in North Carolina, the Petty matter, Virginia, the diamond heist, and the District of Columbia, the breaking into credit union. I was in practice with a legendary lawyer, one of the best I've ever seen in court, Kenny Robinson. And Kenny was a former prosecutor, and then I became his partner for a brief period of time. And the government picked the locked vault case as the first case that they wanted to go forward in. And remarkably enough, it's a longer story, but remarkably enough, he was acquitted, even though he was found after hours in the locked vault. His story being that he had received an anonymous phone call about somebody breaking into the credit union. He had found the doors open went into the vault just to see whether everything was okay. That was his story. And
And then
remarkably enough, it worked.
he got
So, but anyway, it was
Mhm.
quite an experience. I mean, Kenny is a genius in the courtroom. He was the lead counsel, and I was the second counsel, second chair. But a remarkable experience trying the case with him.
Man. So how did the other ones play out? It was one was a credit union.
The Diamond Heist case was a little bit harder because there was
Mhm.
also some tax matters associated with it. So he was eventually convicted of some crimes in the case that we had a few weeks later in Virginia. But remarkable experience.
Man, how much preparation goes into that? Like, how many days are you reviewing discovery, going over your line of questionings, working with witnesses?
These are obviously fact dependent, and I'll
Yeah.
give you an example in another case that I had to make the point. In that one, there was a lot of we went down, for instance, to interview Richard Pettit.
That's crazy.
A lot of it was fact bound. I tried, as you know, an espionage case with Jake Stein, who was the president of the Bar Association here for a while, and another legendary lawyer who was the one lawyer in the Watergate trials that got an acquittal. And I actually watched those trials when I was a young public defender. Jake and I tried an espionage case of a gentleman who was born in China and was alleged to, while he was with the CIA, be spying for Chinese for decades. That case had massive discovery. I had to go out to Suitland, Maryland, and go through thousands and thousands and thousands of pages of files on various things that his name was last name was Chin, had been involved in. So it depends on cases, but there's no substitute for the hard work. I mean, as good as Kenny is, for instance, in trial, no lawyer is good enough to win consistently trials without the preparation, without the hard work. What I call putting your hand on the wound, putting your hand on whether it's favorable or unfavorable evidence. And so each case, has different demands along those lines. When I was at Bredoff and Kaiser trying what they call RICO cases, but large civil cases brought by corporations against unions, some of those cases would have hundreds of thousands, even millions of documents. And I had to figure out systems in which I would be able to try to master all those documents and have them available to me at my fingertips in a trial. So some of it takes days, weeks, and months, and even sometimes years before you're in a position to actually try a case like that.
Man, yeah, I can attest to that as a young attorney. And I've been learning quickly that nothing can replace hard work. Even when like law students or some of my mentees ask me about how do you have that confidence in the courtroom, or how do you prepare for a case, it's like once you're prepared, I feel like everything else follows after. I've never felt as confident in a courtroom when I was prepared. Like when I was prepared, when I had everything set up, when I knew my facts, when I knew the law, I felt the most prepared in that courtroom. And then being able to use that to improvise, and when something goes wrong or if your witness says something different, you can't be able to adjust on the fly unless you are prepared, unless you have everything set. So I had to learn that quickly.
Yeah, and just there's a reality to it. If you're in front of a judge. I mean, a lot of my close friends became judges, contemporaries of mine, both that I tried cases with or against as a public defender became judges. And it's just natural that a judge is going to gravitate if she's in front of two different lawyers or has two different lawyers in front of her. She's going to gravitate to listening more to the lawyer that seems to know what he or she is talking about and has a better understanding what the facts are. That's just simply human nature. And many times, not always, some judges will come in on the bench with a bias and you can't do anything about it. But quite often it's the lawyer that seems to have the best command of the facts that's going to be listened to by the judge. And the same thing works with jurors. I mean, jurors can tell who seems to be prepared and who seems to not be prepared, who's the one that's shuffling papers around and can't seem to find an exhibit, versus the lawyer that seems much more polished and on top of things. These are just, and as you say as well, and you're absolutely right, your own level of confidence is going to be at the highest when you know good and well that you've mastered the materials, mastered the facts. That's just going to allow you another level of expression. I mean, you can see, I mean, like a lot of us, I'm watching the Olympics right now, and what do particularly track and field, but all these sports, what do they talk about when they're interviewed over and over and over again? The training, the hard work that went into it, the mentors that they had, the support that they had. It's the practice of law is not any different. They're able to perform at that extraordinary level because of what? Because of hard work and preparation. Same thing with lawyers. Same thing with the legal system.
Man, can you recall a time where you felt like you weren't prepared? Was there a moment in a trial where you were like, man, this is bad. This is not going well. I should have done a little bit more.
I absolutely can. And I'll never forget it. I remember the client's name. I remember the facts. I remember the judge. I remember every single thing about it. It was, so I came to the Public Defender Service. We talked about that. And I came out of a sequence that I was hired to do appellate work first because they just started me earlier before the training class, which I talked about a little bit earlier, but their training classes are historically in the fall. So I was there several months doing appeals. That led to a case that I ended up arguing in front of the Supreme Court, that appellate work. But when the training class came around, I knew all of the supervisors. Unlike the rest of the training class, they were coming in new. And I'd been around and I'd socialized with them and I'd gone to concerts with them and had dinner with them. I didn't take it seriously. I just didn't take it seriously.
Too comfortable.
I just didn't take it seriously. And so I had a trial, my first one in juvenile court, and I had no idea what I was doing. And there was objections and I didn't know how to respond to them. And I became more and more flustered. And then the judge found my client to be guilty. That wasn't a surprise. But the surprise to me was that I even found myself in trial. I thought I was going to get the case dismissed. And I performed so poorly, this is the punchline, that I walked out. I remember exactly where I sat on a bench, and I cried like a baby. I was humiliated, just absolutely mortified. And I vowed it would never, ever happen again. And that's what led me to watching the Watergate trials and watching the more experienced lawyers and following them around and soaking up as much as I possibly could. I was never, ever, ever going to find myself in that position again. And that was the turning point. That's when I realized, Akeem, that it's the preparation and the hard work has got to go into it. It's just not enough to just put on a suit and claim that you're a lawyer and whatever else, that you actually got to, do the hard work that goes into being a talented lawyer. So that was my wake up call, shall we say?
Yeah, that's encouraging, because I feel like there's times in my very young career that I messed up, and in the moment it feels like the end of the world. In the moment it feels like, how did I screw up so badly? And you just can't wait for the next opportunity to do better. You can't just wait. You can't wait for the next opportunity to make up for that. I think it's encouraging for young lawyers and law students to hear that there's gonna be moments where you make a mistake, where you mess up. You can't allow that to just ruin your entire career or feel like that's gonna stump you or hinder you for the rest of your life. You have to be able to grow from that.
Yeah, I agree from all that. And I'm not saying, and I think it's clear, that I haven't made mistakes and things that I don't spend too much time looking over my shoulder. But, there's no question that if you looked at, tactical decision I made, whatever else, that you might have a second guess on it. But I can tell you that that's the last time I found myself unprepared. For that matter, and over my head, because I hadn't done the preparation work. Mistakes, they're going to come too. I mean, that's just simply part of the whole process. It's very difficult to litigate without making mistakes here and there. But being unprepared is one thing that you can control. That's the one thing
exactly
that's within your control. Outcome, what a jury does, what a judge decides, how a client or a witness testifies, even though you can influence that an awful lot by preparation. Some things are a little bit out of your control. Preparation is not out.
Man, that's so real. So you spoke a little bit about arguing a case in front of the Supreme Court. How was that experience?
Okay. So this is, again, when I said trying things. And just to see what...
Just tried to argue for the Supreme Court justices. Right. No big deal. I just tried it out.
But it's a pretty good story. So I'm at the public defender. I'm not licensed yet because I've got to wait, to be sworn in. So I'm going around and asking people, doing appeals, to what I can do to help. And I start doing bond motions for people to try to help if a client was locked up, filing emergency appeals and things like that. And I came across a lawyer in the next office, and he had a client who had been arrested in a kind of a dragnet arrest. They were just simply rounding up, black youths without any probable cause. So I said, well, let me write a motion to suppress. So I did, and it was denied. And so we took it up on appeal. And the argument was the government didn't disagree that it was an illegal arrest, and they didn't disagree that the out-of-court identification should be suppressed as what we lawyers call a fruit of the poisonous tree. But I argued that all the identifications, including the identification in the courtroom, should be suppressed as well. So that was the issue that I framed at the trial court. I argued it in front of 3 judges in the Court of Appeals. They basically laughed out of court. I filed a petition for rehearing, and by a miracle, the court in bank overturned the panel decision and agreed that the fruit would be not only the out-of-court identification, but the in-court identification. The Solicitor General's office did not like that outcome, and they filed a cert petition. And I found myself on this motion that I had done on the back of a napkin 2 years earlier, now arguing the case in front of the Supreme Court. The Supreme Court did not agree with my argument and overturned quickly the Court of Appeals. But it all started with just simply a random running into an acquaintance, giving him advice, drafting the motion for him, and then later arguing the case twice in front of the DCCA. I mean, and that's what I mean by extending yourself and putting yourself in many situations as possible, because who knew that 4 or 5 years out of law school I would be in front of the Supreme Court, but that's where I found myself.
Man, amazing. I can't even imagine. I'm sure the nerve, was the nerves there? Like when you walked into
they were. And I was treated pretty harshly by then Judge, maybe he was, I don't know if he was a Chief Justice then, but Rehnquist. I made some statement about, we need to send a message to the police. And he turned it around and said, we need to send a message to the victims, not the police. I mean, it was a tough go for me, for sure.
Yeah.
But quite an experience. And yes, I have to confess, there was some nerves involved in terms of nervousness involved.
Man, that's amazing. Well, so speaking of justices, why haven't you become a judge? I'm sure opportunities have been there. I'm sure you got approached for it. Why haven't you become a judge?
I think by temperament, I'm more of a player than a referee. And I have done some mediations a couple times, in which you're playing more of the kind of a judge role. You're trying to bring the parties together. But I think by personality, I'm more suited to be out on the playing field as opposed to being a referee. So, and I enjoy the collegiality of working with other lawyers together. Judges, a lot to be said for the work that they do, but they're generally not, isolated. 1 or 2 law clerks and a small staff, whatever else. But they're rarely in a situation. Most of the big cases that I've done over the years have been with working collaboratively with other lawyers. It's one of the things that I've enjoyed in the practice of law. So for a variety of reasons, that's not the trajectory that I ended up following.
Man, that's real. I like the analogy of being a player, being in the field. Because I was telling my wife sometimes, I'm like, I don't know if I could be a trial lawyer for like 20 years. I think it's tiring. How do you have the energy to still be in the field, to still be on the court, putting up 25 and 10, like LeBron is like about to be 40, and he's still jumping out the gym. Well, how do you feel like you're able to continue on?
You asked me earlier what the attributes into a trial lawyer, and I talked about storytelling. But I do think that having a competitive streak in you is part of it. And I definitely do. And even to this day, whether I'm competing with other people in the particular sport that I'm doing, or even competing against myself in terms of running or biking or whatever else. But having, as long as that competitive streak stays with you, the desire to, just to be crass about it, the desire to win, which is not to say that being a trial lawyer, and particularly a defense lawyer, is a good path towards being able to do that on a regular basis. I mean, particularly being a defense attorney, you're almost always, as you know from your experience so far, you're almost always dealing with a limited amount of cards in the deck. I mean, almost always the prosecutor's got many more cards than you do, and you've got to figure out a skillful way to use them. But having a competitive streak anyway is what has kept me going, and still keeps me going. I mean, the death penalty that I have case down in Texas is going to be a very challenging case, and I know the amount of work that's going to take to be successful in the case. And I'm determined to make sure that work is done. I can't guarantee what the outcome is going to be, but I will guarantee what the level of performance is.
Yeah. Can you speak a little bit about, and obviously you can't go into detail, but about the cases that you're handling now in Texas with the death penalty? What is the context of those two cases?
Yeah, it's first of all, as you may know, but Texas has almost 300 men and women on death row, if you can imagine. This is a case that's was tried in Houston in 2017. It's somebody who immigrated through this country from Jordan, and he's a Muslim. And unfortunately, when the case was tried in 2017, it was just after Trump had announced the Muslim ban. So there was a lot of hysteria and pretrial prejudicial information that was floating around. He was alleged to have killed 2 people, and the trial was tried in a kind of a circus atmosphere, as far as I'm concerned. So in Texas, to expedite the death penalty process, after a trial, they're on 2 different tracks. One track, you have a direct appeal, which is based on what's in the record. In other words, what the issues were in the record. That's a separate group of lawyers that have already briefed that and argued that case, and it's pending decision in the Court of Appeals in Texas. At the same time that you're doing that, you're also doing a post-conviction hearing in which you're alleging things like ineffective assistance of counsel, Brady issues, and other issues that are outside the record. And so that's I'm working with a team of lawyers on that part, post-conviction. So there'll be a hearing right now in January in which issues collateral to the record are being raised, have already been raised, and my job is to help that team present the witnesses in support of the petition that's been filed. So it's a mammoth undertaking. The petition itself is 300-400 pages long. The trial went on for months. The jury selection alone was a month. 100-some witnesses testified for the government, for the state. So it's a huge undertaking.
Yeah. And how long do you think this process is going to take? Is it going to take another couple of years?
Yeah.
Or months?
So the way it works, so there'll be an evidentiary hearing, probably, not certainly, but probably late January, February. The judge will then make findings of fact and make a recommendation. That goes up to the Court of Appeals. So keep in mind there'll be 2 things that'll happen. The Court of Appeals still hasn't decided the direct appeal, and separately, another panel will have the recommendation from the trial judge as to the post-conviction issues. If either one of those are successful, the hope would be that there would be a new trial either on the both phases, or at least on the punishment phase. If that all fails, that's when you go into federal court. And the importance of raising all these issues in the state court is that if you don't raise these issues in the state court, you can't raise them in the federal
You can't raise them.
So this could
Yeah.
go on theoretically for 2, 3, 4 years, I suppose. I mean, at least, because it won't be until 2025 that the Court of Appeals will even be looking at the post-conviction findings, and depending on the outcome of those, will control whether the gentleman has to go into federal court to seek relief.
Yeah, that's real. How do you pick cases now? Like, what makes you choose a case to work on? Is it the variety of the facts, how difficult it is, the complexity of the case? How do you make that decision?
Yeah, I still get, I'm in what I don't like to use the word R or the semi-R word. I don't consider myself either retired or semi-retired. So I pick and choose cases that seem interesting. I've done a couple labor cases and a couple of criminal cases in the last year or so. But the death penalty, a lot of public defenders, former public defenders have gotten into that space. Some legendary lawyers, Steve Wright, for instance, is a legend in the capital punishment death penalty. Henderson Hill, several other lawyers, Lisa Greenman. And a lot of them have gone down to Texas and gotten involved because, as I alluded to earlier, there's almost 300 people now that are on death row. And I know a lot of those lawyers, respect them. Some of them I even actually trained. And I've been fortunate in my career. I've tried scores of murder cases, usually successfully, but never had to try a murder case in a capital punishment jurisdiction. And it's always been in the back of my mind that one day I would get involved in that. One thing led to another, phone calls here and there, and the opportunity came along to get involved in this particular case. And so it gets back to what we've talked about. It's expanding my own experience. I continue to grow as a lawyer in terms of my involvement. My competitiveness, I suppose, is part of it. And my desire, I suppose, to do something socially, what I consider to be socially useful, would be another component to it.
That's real. So I'm going to ask you the age-old question that I always ask the defense attorneys that come on my podcast. And I feel like the regular list, the layperson always wants to know this. How can you defend a murderer? How can you defend a bank robber and a CIA spy and all these different things? Like, how can you defend somebody who the outside looking in looks very much guilty? All the evidence is stacked up against him. How can you defend this supposed terrible person?
So I'm going to suggest that your viewers actually read a book, and the title of it, remarkably enough, is "How Can You Defend These People?" It's a book by a friend of mine. His name is Jim Kuhn. When he was in law school, he wrote a best-selling book that was #1 in the New York Times. He came to the Public Defender Service as an attorney, was there for a few years. I was his supervisor. And after he left, he wrote a book called "How Can You Defend These People?" And it basically is a defense and a response to what you're asking. But let me come at it another way, which explains why I became a public defender in the first place. So I'm in law school, and I'm 21, 22, I guess, going on 15. I mean, I'd never met a lawyer before, and it was in the first place. But I was in law school, and there was a legendary professor by the name of Yale Camisar that was teaching a criminal procedure class. Camisar is responsible for Miranda versus Arizona. He wrote all the law review articles, and if you read Miranda, you'll see footnotes in which he is responsible for the whole concept of why you should have counsel on Miranda issues and constitutional issues, not only in the courtroom, but as he called it, in the gatehouse in the police station. Anyway, there I am, 300 students, way in the back, listening to, he was quite theatrical, Camisar. Again, as naive as could be. And Camisar said that in this country, our country, a poor person was entitled to the same level and quality of representation as a wealthy person. I thought that was the most remarkable thing I'd ever heard in my life. He wasn't saying that was happening, but he said that aspirationally, that's what the society and that's what the Constitution demanded. I thought that was the most Amazing thing
Yeah.
that a society would care that much about the downtrodden and the poor, that it would actually have an aspiration like that. And I decided at that moment that I would be a public defender. And that became the reason that I did a clerkship that Camisar helped with, and then that I came to the public defender service, and I described walking into the bar and being able to go upstairs and see these
It's confirmed.
kids, and
Yeah.
it led from there. But it was that was the wellspring. That was the beginning of the whole thing. And that I've stayed true to that. I'm on the board now of the Neighborhood Defender Services, which is the best public defender other than PDS and DC in the country. I was on the board of the PDS for a long time. I helped start an organization called Gideon's Promise that recruits and trains and mentors lawyers to represent poor people in the South. The idea of being a public defender, I married a public defender, for God's sakes. I mean, my wife was a former public defender.
It's called dedication right there. That's dedication.
So, and I, so that's the answer is, I think that it's important to the system that no matter what the appearances look like and the amount of evidence that's against a person, that you have a criminal justice system that works that way, so that the prosecutors, and I had no hesitation, by the way, as you know, Akeem, of training prosecutors to go into court to battle against public defenders. I mean, as long as the system is balanced and there are good lawyers on both sides, I have a lot of confidence, not always, but most of the time, that you're going to get a just result if you've got good lawyers on the state side and good lawyers as public defenders. But the real need across our country is on the defense side, because that's the side that's usually most poorly funded.
Yeah. Man, as you said, the evidence and the resources are usually stacked up against. It's definitely an uphill battle for defense counsels in terms of the law, in terms of resources. Yeah.
And that's why, being a public defender, you do learn skills. I mean, so in the rules of the game, if there's 52 cards and you're a prosecutor now and I'm just the defense attorney, you're going to have 49 cards. I'm going to have 3.
Yeah.
That's just the way it is.
Yeah.
The skilled defense attorney knows how to play those cards at the right moment, maybe even in an unorthodox way, and maybe even getting right to the borderline of what the rules of evidence will allow to play them. And because if I play them the way the rules are, you play a card, I play a card, you play a card, I play a card, you play a card, I play a card. After 6 cards, I have no cards left. And so I've got to figure out a way, and that's what a good defense attorney learns how to do, and that is to maximize what they have, and it's always going to be less than the prosecutor, in a way that's most effective and becomes compelling to the jury and supports a narrative, even though you have fewer cards to support it. That's really what a good defense attorney is all about.
Absolutely. And I've seen, I come home and tell my wife all the time, I'm like, I just heard the most insane argument for the defense attorney or this, and they try it and it works sometimes. And I'm like, how did you flip this or use it? Like, that's not what that means. Or they pull it out of anywhere and and it's impressive. And in the moment, it's frustrating.
Yeah.
Because obviously being on the other side, I'm like, no, that's not what that means. You can't put that there. You can't. No, what are we doing here, Judge? But then afterwards, I'm like, that was impressive. I have to give it up to them. They tried. They had to use what they had.
Yeah.
They didn't have anything else to argue, but they somehow, some way took the backdoor exit or put through the side. And it's in the moment, it's frustrating. It makes my blood boil, and it goes to the moments where I felt like, how could I let this happen?
Right.
But after I have to give them props. I'm like, man, that was impressive.
Yeah. So, and another part of all this, Akeem, and you'll learn this as you grow, is to anticipate things like this.
Yes.
One of the first things that I would do, I would have these big RICO cases against corporations that were suing the steel workers, or one of my clients, SEIU. And one of the first things I did before I did what my opening statement would look like and what my evidence would look like, I would do theirs and figure out what is their best line of attack. How are they going to defend or prosecute this case, whatever side I happen to be on, and think through as best you can what the other side is going to be doing, so that you are as prepared as possible for what it is, because you're absolutely right. And particularly, again, the defense attorney, she is going to be not playing those cards when you're expecting them to be played. She's
Exactly.
not going to put those cards out there right at the beginning. She's going to pick the right moment and the right witness and the right cross-examination and the right exhibit to make her point. And you've got to do the best you can to be thinking through, what would I do if I were in her shoes? When I know what card she has, although not always. You might not know, some investigation that she came up with, but you should know probably most of the cards that she has. But how is she going to play them? And that when you get to that level, it's like chess, basically. Now you're anticipating already what limited moves the other side has, and you're doing what you can to kind of wall it off if you're on the prosecution side. But that's what comes from the challenging work of being a defense attorney, is to learning how to play those cards as skillfully as possible.
Absolutely, man. Still coaching me, Gary. I appreciate you still coaching. I think it's a perfect way to end. How we usually end the podcast is something that you're very familiar with, is closing arguments. It's basically you just leave the audience with a word of encouragement, whether it's a tip that you want to leave or a summation of what we talked about. Whatever it is, it's a closing argument. It's a gift to the listeners that you want to leave them with, what you want to encourage them with.
All right, and I've got it. I'm, that's part of the skills of a trial lawyer, so you can do this off the top of your head.
Yeah.
So here's what I've enjoyed and what I encourage any of the listeners to try to find. I've never actually had to go to work. I've enjoyed what I've been doing from public defender days on, so that I've actually looked forward to going to the office, working on cases, trying cases, whatever else. Find, if you can, something that you have a passion about, something that you care about. And if you do, your life is going to be just, so much more rewarded, basically. If you can find that thing that keeps you going and keeps you working, and strive. The other thing I found, and particularly in litigation, is that it's not always, as I talked about earlier, it's not always easy to guarantee what the outcome is going to be. But the one thing that you can do, your own capabilities. You know how good you can be. Do what you can to make sure that you've given that effort every single case that you do, because then you'll be able to live with the disappointments. The disappointments are going to come. The losses are going to come. The bad rulings are going to come. If you can walk out of a courtroom or walk out of your office, whatever you're doing, knowing that you gave it your best, that's the best way to survive the kind of the bruises that come with the legal system. So find something that you care about and have passion for, and then perform at your highest level. And if you do those two things, you'll have a great career.
Man, Gary Kohlman, ladies and gentlemen. Gary Kohlman, amazing closing argument. Thank you so much for being on the pod. I don't think it's an understatement to say that you are one of the best trial attorneys in the country, maybe the world. You still working out, maybe. I'm not scared of saying that. Your resume speaks for itself. Just knowing you personally, an amazing person, an amazing attorney. So I just want to thank you for being on the podcast. This was great, and I'm sure the listeners are going to enjoy it well.
All right. Well, it's been a pleasure. It's always been a pleasure being around you, Akeem, and it's been a pleasure to be on your podcast.
Thank you.